So hello everybody, I'm Haider Hamoudi for those of you who don't know me. I'm a professor here at the School of Law, and also I want to thank CILE, which I think does really a great job of not only supporting faculty but also by bringing in the LLM students, really enhancing some of our classes. Those of us who do and do international and comparative work and are interested in that work always have the benefit of having LLM students in our classes, so we can use that opportunity to introduce American students to foreign systems of law and foreign ideas, so that they don't internalize American norms to such an extent that they're not aware of anything else. Most of my work relates to either Islamic law or the law of the Middle East. And I've been doing a number of different projects. One that I think I've discussed at a CILE, the 25th anniversary last year, was a casebook that I'm writing on Islamic law. A lot of Islamic law studies tend to focus on sort of juristic theories and what a 14th century scholar said about this or a 17th century scholar said about that. And I'm more interested in how Islamic law tends to work on the ground, as a lawyer operating in Muslim states where Islamic law is the operative law in some contexts, family law and elsewhere. And so that's certainly one thing that is sort of a multi-year project that is hopefully coming to an end by this time next year. The other thing that I've been, a couple other things that I've been working on, I just came back from Doha, where I had a conference on judicial independence and judicial ethics. And I've been working a little bit on this subject, in particular with respect to the Iraqi judiciary. There's two areas of academic literature that have been developing. One is this idea of repugnancy, this idea that all legislation, constitutions in Afghanistan, Iraq, elsewhere, Egypt, have started to say, well, you can draft legislation all you want, but it can't violate certain norms of Islamic law, and empowering courts to do that. And there's another body of very interesting academic literature that's starting to say, empowering courts excessively in new democracies is not a particularly good idea. Everybody thought it would be a good idea after South Africa, but South Africa was kind of a unique case, common law jurisdiction, generally independent judiciary, to obviously in the service of a horrible regime, but at the same time independent in some ways. And there's a lot of areas in which that's just not true in other parts of the developing world. And I think these literatures are sort of speaking past each other. In particular, no one's sort of putting two or two together to show if we really empower courts to set aside legislation because they decided it doesn't meets or doesn't meet with Islamic norms, are we in some ways or other empowering these courts to act in particular anti-democratic fashions that could be dangerous to the sustaining of that democracy? And I conclude from the Iraqi experience that that's precisely what's occurring and has helped to facilitate, it did help to facilitate Maliki's growing authoritarianism. And a final subject, I guess, actually two other quick things that I'm working on. One has to do with, and this involves some consulting with the Iraqi parliament as well, there has been a move to do a lot more Islamizing of the Islamic charitable trusts known as the Waqf that has existed throughout Islamic history. Within Iraq, that movement has actually taken place to a very strong degree, where there's been efforts to maybe repeal elements of personal status code, marriage law, et cetera. Those have generally failed. But in the area of Islamic charitable trusts, there has been a lot more advancement. It doesn't involve as many controversial issues, with respect to women's rights and the like, and so it is able to succeed more. But that has happened is create remarkable levels of entanglements, such that clerics in Najaf who aren't really state officials get to sort of choose who sits on the Waqf board of the state, and the Waqf itself is then administered by someone who's effectively chosen by a cleric, and this creates a great deal of entanglement. Usually when you talk to Iraqi parliamentarians, or when you started to, that's just entanglement language, this is all you Americans and your lemon tests, and we don't care about any of that. But it actually does create difficulties, which I think they've begun to realize, partly because the juristic institutions in themselves, in Najaf itself, are Waqfs, that is to say, they're charitable trusts. They're created that way. That's how they exist. And this creates an entanglement. This creates something of a difficulty because it's very hard for the state to be able to regulate an institution which itself is appointing the members of the state. And what happens if there's internal disputes within these institutions. And the final thing that I've been working on is a legal pluralist project that I was working on with one of my SJD students, a current SJD student, Wasfiya Shara. And that has involved looking at the ways in which Iraqis in particularly tribal areas of the country, and particularly we've done it with respect to commercial actors before. Now we're looking at women, how women sort of get to choose, or how they choose, between whether or not they are seeking a tribal resolution to a particular dispute that they're having, or the state. Right? It is not necessarily obvious which one is the better choice. It obviously depends on the circumstances. What is quite remarkable is the tribes have their own forms of resolution, which they claim derive from Sharia but don't. The state has its own, which claims it derives from Sharia but doesn't. They're clearly in some level of competition with each other, but at the same time, there's a remarkably diminished sense of contradiction among the women themselves when they're sort of deciding which one they want to go to. That is, they're not saying, well, these are inconsistent. They're just sort of viewing these as two avenues to sort of reach a particular goal. And the ways in which these sorts of decisions get made, why they get made the way they made, how these systems can continue to operate in this kind of complementarity is, I think, a very interesting subject, and I've been working on that as well. So that's a brief summary of some of the things that I've done, and repeating thanks again to Ron and all the folks at CILE who make this much easier to do.